We all here. Good morning, gentlemen.
Morning, Your Honor.
Are we ready to proceed?
I am.
How
Yes,
much
sir.
time would you like for rebuttal, sir?
3 minutes, please.
All right, you got it.
May it please the court, Michael Carey for the appellants, Sharif and Ismet Ozer, who I will collectively refer to as the Ozer parents, and also Omer Ozer. Our first point on appeal is that the trial court erred when it, after the close of plaintiff's case at trial, the trial court sua sponte amended the pleadings to add the Ozer parents to a breach of contract count which had not been pled against them. If you look at the plaintiff's complaint, Starr apparently made a tactical decision when it filed that complaint to sue only Omer Ozer, not his parents, for breach of contract on the big house, what we referred to as the big house. The Ozer parents were not named as parties to the breach of contract count. They were named only to the unjust enrichment count. Now, whether this tactical decision was based upon perceived collectability, a misunderstanding of the law, or some other tactical reason really doesn't matter. What matters is this was the tactical decision that Starr made. Now, there's a suggestion in Starr's answer brief that somehow there was a mistake or trickery. Well, I respectfully suggest that ignores the record. If you look at the record.
And if I, Mr. Carey, can I
Sure.
jump in? As I understand, it was the issue before the court, and it sounds like the court, when he allowed the amendment, basically dealt, maybe he handled it more as equitable. It boils down to, as I see this, the issue becomes whether there was notice and due process. So in this case, Mr. Carey, help me out. These parties, as we all see based on the record, litigated this for 5 years. Same parties, same lawyers, same everything. In fact, I think even the judge indicated that. So by the court allowing that amendment, did your client basically have an issue with notice, did not get due process by the courts allowing that amendment?
Absolutely. The Ozer parents came to the court prepared to try a case on the big house for unjust enrichment. By virtue of a sua sponte amendment, after the close of the plaintiff's case, they were forced in the position of trying a case for breach of contract.
And what would be different then let's walk it through, because I think it's Ozer's mood for judgment of dismissal after, the Starr's claim for unjust enrichment. So what would you have done differently? What would you have called different experts? Would you have called different things? Where is this problem?
We very well may have. The problem was we didn't have the opportunity. We were prepared to try one case, we had to try the other case. It's really not a lot different than the Freshwater versus Vetter case, which this court decided. In that case, you had a plaintiff suing a corporate defendant for fraud and suing the president of the corporation under an alter ego theory. All the evidence at trial had to do with things the president said and did. That was the central issue in the case, according to the reported decision. At the close of the plaintiff's case in Freshwater versus Vetter, the trial court granted a directed verdict in favor of the president, finding there was no evidence of alter ego. However, it allowed amendment to pursue a simple fraud claim against him. The case went to the jury. The jury ruled against the president. On appeal, this court reversed. They held it was an abuse of discretion because they allowed the amendment after the close of evidence. The court abused discretion to plead a cause of action that had never been pled against the president before, even though all the evidence dealt with it. Pretty much the same argument not you're making an argument, but pretty much the same fact situation you're given, Your Honor, is that at some point in time, and that's at the close of the evidence, it becomes an abuse of discretion because you're depriving a party of procedural due process.
Mr.
And
Carey,
I'm curious-
Mr. Carey, one question is, the Vetter case is a tort case involving fraud. It's undisputed there's a contract in this case, whether the contracts with just Omar or all the Ozers was an issue. Plaintiff went under unjust enrichment, which means there's an implied contract. And what's the implied contract? It relates back to the contract. So the contract, as I read it, where it was approved, there is an indication that it's approved with changes, which may even take it out of the Paskin case in terms of extra work. Then the court finds that the Ozers agreed, and therefore they had a contract with Star. Is that different?
I mean, I think
You have an unjust enrichment is based on an implied contract. Fraud is different. So help me out.
okay. Well, the implied contract gets into the unjust enrichment theory. Okay.
Well, but you would agree with me, you have to have an implied, unjust enrichment is based on an implied contract.
Correct.
And there's no doubt that the contract that's implied in this case is the original contract with Star, correct?
No, there was an express
How
contract.
so?
There was an
Well,
express
that's
contract.
what I mean, the express contract.
Yes.
And
The
this
implied contract, the implied
has a
contract,
signature line that says with changes. So I don't know if that contract, you could say the contract includes change orders or it doesn't. And then, so the parents, according to the court, and I don't know that you take any issue with the court, because the court said that they were very demanding about these changes. It wasn't just Omar, it was the parents. So help me out.
let's be clear, there were express contracts with respect to the base contract work and with respect to the request for change orders or RFCOs for which there were signed writing. However, there were a number of RFCOs after the base contract for which there was no signed writings. Those are the implied contracts. Okay, on those, there were never any agreements as to price. There were never any acceptance. That record's undisputed as to that. Even Max Sanchez, the president of Star, admitted that, yeah, they rejected that requested change order when I presented, because the requested change orders weren't presented until after the work was already done. So that is what your implied contracts on. But go to the base contract for which there were signed contracts. It is clear that those were there were to the extent there were express contracts, the Ozer parents were never sued on those. And this was something that was repeatedly called to the attention of the plaintiff. First of all, they pled it that way. You look at the count, the title of it is against Omar Ozer for breach of contract. Then you've got who'd they say made the contract in count 2 of the complaint? Omar Ozer. Who'd they say breached the contract? Omar Ozer. Who'd they ask for relief for? Omar Ozer. Never once did they mention the Ozer parents. We called this to their attention when the Ozer parents answered, this count not directed to this defendant. Therefore, you didn't respond to the corresponding numbered paragraphs. When we submitted our proposed findings of fact, conclusions of law, and final judgment prior to trial, we pointed that fact out again. At the beginning of the trial, I announced the Ozer parents are not trying any unpled breach of contract claim against them. I acknowledge that the unjust enrichment counts for the unsigned RFCOs were the proper subject of unjust enrichment claim against the Ozer parents, but the express contract was not, because it was never pled against them. The other thing the court did, the second point we have on appeal, is that the trial court found the Ozer parents liable for breach of contract on the unexecuted RFCOs on the big house, and Omar Ozer liable for breach of contract for the unexecuted RFCOs on the small house. Now, if you look in the record at the beginning of the case, before the presentation of evidence, there was a discussion with the court in which it was acknowledged by both counsel that the unexecuted RFCOs were being pursued on a theory of unjust enrichment, not breach of contract. The record evidence, as I mentioned before, was that there was no agreement on two essential terms for an express contract: acceptance and price. There was never an agreement on price with essential terms. There was never an acceptance of the RFCOs. The trial court found that there was a series of contracts based upon what they described as a course of dealing.
And if I may, Mr. Carey,
Sure.
because I see what you're making that argument, but in this case, what the court basically did, based on the evidence presented, was not more of a factual determination. And in this case, regrettably, he found in Starr's favor based on the testimony and documents. And he went back and it appeared like the son had signed some of the shop drawings that reflected, significant changes to the initial estimate. Starr relied on that and performed on that. So the court took all that into totality, and it being a factual determination came to that conclusion. Why would that be in error?
There was never any agreement on price, and therefore it can't be a contract, can't be an express contract. It can be an applied contract, but it can't be an express contract. You have to have all essential elements of a cause of action for contract, even if it's an oral contract, and you must have an acceptance, which the testimony from Starr's president was they never accepted all these unexecuted RFCOs. They were rejected. And second, there was never an agreement on price.
Okay,
So
by
therefore
saying,
they must travel
if I
under.
may, okay, you said that there was an actual testimony that they rejected these amounts?
Yes, repeatedly. They repeatedly, Mr. Sanchez, the president of Starr, admitted that, yes, the Ozers never accepted the dollar amount of the RFCO. So, and that's why you can't have an express contract. It had to be an implied contract. So the finding from the trial court that you had this series of contracts can't stand. At best, you're going to have an implied contract. So let me next address the implied contract, which is the third point we raised on our appeal. The only implied contract claim that was pled was for unjust enrichment. According to Passion case, the measure of damages on an unjust enrichment claim is the value of the benefit conferred on the plaintiff. It's not the amount the plaintiff wanted to charge for services. It's not the cost of the plaintiff. It is the value of benefit conferred on the defendant. Now, Starr attempted to prove damages for unjust enrichment in two different ways. One, it introduced the unexecuted RFCOs. Well, that's exactly what the court in Passion rejected. A proposed change order is insufficient to establish damages for unjust enrichment. The proposed changes shows what the plaintiff wanted to charge, not the value of benefit conferred. Second, Starr introduced expert testimony of Richard Hartman, a local architect. Mr. Hartman testified to what he admitted were ballpark estimates of the value of all the cabinets in the big house and a second estimate of all the cabinets in the small house. The problem with this and the flaw in Mr. Hartman's testimony was that all the cabinets in either house were not the subject of the unjust enrichment count. What was the subject of the unjust enrichment count was only those cabinets which were subject of the unexecuted RFCOs.
Sure. So if I may, Mr. Carey, having said all that, I guess the bottom line, as I see it, the son went ahead and signed for the major changes, okay? Then Starr did the work. Then your clients refused to pay. So the issue before the court was how much they owe for completed work. So there was a whole bunch at trial, a lot of different theories as to which bills are valuable and how much. The court, having it being the trier of fact, came to the conclusion and basically relied on the testimony, which is their prerogative, on Starr's principal and Starr's expert. And even though the expert did talk about different things, it appears that what they relied on were basically it was the documents, what the court relied on, the documents, the principal, the expert. So this is all before us. So how can that be a lack of sufficiency of evidence for unjust enrichment?
Well, first of all, go back to what I said earlier. To the extent you have a contract, and there is contract for the base contract amount, and there's contract for the executed RFCOs, that cannot be the subject of unjust enrichment, right? Because the contract precludes a claim for unjust enrichment. So the RFCOs are the only basis you can have for unjust enrichment. Well, what they should have done is introduce expert testimony that the cabinets that are the subject of the RFCOs had a value of X, and that's the value of the benefit conferred. But the flaw in the way they proceeded is that Mr. Hartman testified all the cabinets, both the contractual and the non-contractual, the unjust enrichment, the unexecuted RFCOs, are worth X amount. I think it was $75,000 for the big house and $15,000 for the small house. Well, there's no way to break that down. Mr. Hartman admitted he could not break that ballpark estimate down between the executed RFCOs and the unexecuted RFCOs, between the base contract and the RFCOs, or by room. He couldn't do it. So the simple matter is that while they did have a legitimate claim for unjust enrichment for the unexecuted RFCOs, they failed to prove the measure of damages. They had a guy give a ballpark estimate. They had some unexecuted RFCOs. That fails to prove, that fails to meet their burden of proving what the value of the benefit conferred. Then we go to the fourth point of our brief, and that is that the amended judgment improperly includes damages on both houses that were either contrary to or not supported by the record evidence. The standard review as to the trial court's methodology in calculating damages is de novo. STAR's damage calculation included employee labor that was marked up 300%. On top of that, they added a 35% labor burden and a 30% overhead and profit. So the total markup was 526.5%. At trial, they did reduce the labor burden from 35 to 14.3 because they agreed my expert was correct. That brought the total percentage down to 445%. Their own expert, Mr. Hartman, testified that generally 5 to 25% markup on change orders would be appropriate. Maybe 30. They have 445 plus. They also included overhead and profit on the labor burden that they removed out, the incremental amount. And all these amounts are detailed in our brief.
And if I may, Mr. Kerr, I appreciate, because I know you laid it on the brief. As I'm reviewing this, was this actually preserved? Because you filed a motion for reconsideration, but you all abandoned them. And the motion for reconsideration, that could have really given the trial court the opportunity to correct any errors that you're taking issue with. So how is this issue preserved for me?
It was preserved by my expert at trial, Matt Larkin, testified to each of the numbers that are in point 4 of our brief.
You're into your 17 minutes. You can use it as you like. So I just wanted to give you the
Thank
notice.
you. Okay.
Yes, sir.
The amended judgment also improperly included labor burden on subcontractors, which their own expert admitted was wrong. And the amended judgment failed to give the Ozers credit for base contract work that was not performed. They don't even try to rebut that in their answer brief. So the bottom line is that the trial court erred in multiple ways, but you really got to focus on the unjust enrichment to the breach of contract count, not look at this globally, which the court did, because that's how it was pled and that's how it's properly considered. So I'll reserve my rest of my time for a rebuttal. Thank you.
All right, sir, you'll have 2 minutes. Thank you very much. Mr. Adams.
Good morning. May it please the court. David Adams on behalf of the appellee Star Quality.
And Mr. Adams, I'm going to ask you the same question that I asked Mr. Carey at the outset. It appears to me the manner in which the court allowed the amendment is because the Ozars filed a motion for judgment on the pleadings. And this, I guess I'm reviewing it. This was after the pretrial stipulation that no pending motions remained. So as I review this, when the court granted that, the court basically looks at, is there a due process issue? Is there a notice issue? So the same question that I asked Mr. Carey, was there a problem with due process, with notice? We are dealing with the same parties, pretty much the same issue. There's no question that cabinetry was done, work was done. It's just a matter of a dispute as to how much is owed. Was there any issue of due process or notice by allowing this amendment to go through?
That's a good question, Judge Kuzan. I would answer the no. And the reason why is the parents were always part of this action. Count 3 did name Omer Ozer as the breacher of the contract, but he acted as the agent for his parents. And as one of the court members pointed out, the parents were there at the time this work was being done and at the time that the work was being amended. The record is replete with evidence from Mr. Sanchez, the principal of my client, who said, while he was explaining these things, he was writing things on the wall and the parents were nodding their head and giving input on this. So as far as notice goes, the parents were always part of the case. All of the change orders for all of the parents' claims on their house are attached to the complaint. It's hard to believe that you wouldn't understand that the parents are part of the complaint. Now, we did make a mistake in, alleging it against Mr. Omer only instead of the parents. This case started out with 2 complaints, one in county court for Mr. Ozer's house because it was only $10,000, and then one for the parents' house because it was over the jurisdictional limits. And eventually they got consolidated and we tried the case all together. But the bottom line is the parents were always part of the breach of contract action and they were on notice. Keep in mind, there was never a motion to dismiss on the parents. There was never a motion for summary judgment. It wasn't pled as an affirmative defense. It came up as a directed verdict 2 days before trial. So,
but it's not really, but it was not a directed verdict. Didn't they file a motion for judgment on the pleadings?
They did. You're absolutely right. Excuse me.
No.
And to your point, there was no prejudice to the defendants. All of the defendants, and this is in the record, in the judgment at, excuse me, I'm having trouble finding that, but anyway, it's paragraph 84 of the judgment. All of the defendants were related family members. All of the defendants were represented by the same attorneys, which in this case, over the 5 years, were about 3 of them. And the parents knew that their son, Omer Ozer, was negotiating on behalf of the millwork. So I get back to the text of the rule, which says parties may be added by order of court on its own initiative or on a motion of any party at any stage of the action on such terms that are just. And that's
Mr. Adams, it doesn't look like you added a party. You added a cause of action against a existing party. The parents were already parties here. You didn't add them. So how does that rule apply?
Well, that's true, but we added, under count 3 of the complaint, we added the parties, which were the parents, as to count 3. So you're right. The parents were parties in the overall case, but as it relates to the breach of contract claim, they were not named in count 3. And so we believe Rule 1.250C allows the court on its own initiative to add them as parties as to count 3 of the complaint, which was the one for breach of contract. Then it gets back to the point, essentially, Judge Kuzan, that nothing would have been done any different as to how the case was tried. The expert witness for Mr. Carey testified as to all of the faults for all of the change orders for all of the parents' house. So essentially nothing, he would have done absolutely nothing different because the parents were already named in the unjust enrichment claim and his expert witness testified as to all those items. And as to Judge Sleet's point, this is a contract action. This is not a fraud action. And basically we pled the unjust enrichment in the alternative in the event that the breach of contract, didn't stick. And so as a result, the parents were always present during all of these changes. And Mr. Ozer, as identified by the court, signed off on all of the changes. We had, plaintiffs 6 through 9, exhibits 6 through 9, had all of these plans with all of these markups on them, and Mr. Ozer expressly accepted them by saying, agreed with changes. And that's as to the parents' house, and as to his house, he just signed it, and he didn't write the words with changes, but I think that's implied. So that is important. Anyway, getting back to my argument here, Judge Wolf's ruling should be upheld because adding the parents to the breach of contract claim was just and equitable because the parents were part of it. There was
Well, I have another question about that because as I read the transcript, he cited the Arminger case, which really has nothing to do with 1.250. And I think you would agree with the Vetter case. However, amending it to state a new cause of action should not be allowed over objection. So if Judge Wolf referred to Arminger for support, Arminger reversed the trial court and said that the plaintiff's amended complaint, or whether it's the third amended complaint, related back to the initial complaint. I mean, you did make an argument in your brief concerning 1.190. Are you still arguing that too as an alternative or not?
I am arguing that an alternative, but Your Honor, the Vetter case simply is not persuasive. First of all, it's not a case that involved 1.250, which is what the court ruled in this matter. And the Vetter court opined that pleadings could be amended at the discretion of the trial court. What the Vetter court disagreed with, that a new cause of action could not be added. And again, the breach of contract claim was in the original complaint. Yes, Judge.
And Mr. Adam, I guess as I see the argument, you added an existing party to an existing claim. Isn't that right?
It is indeed. And as a result, there was always a breach of contract claim for the millwork on the parents' house. And Judge Wolf only amended the parties, as Judge Kuzan pointed out. He did not add a new cause of action. The breach of contract claim was always there. And importantly, under Rule 1.250C is not the same as Rule 1.19, and there are different standards for application of each. As a matter of fact, this court recently talked about this in CHHS Hospital Company LLC versus Harmon. It's a March 2024 case where the court stated, but even where the motion to amend is not filed until shortly before trial, the justice factor can outweigh the prejudice factor of the opposing party caused by having to prepare for a new issue. Typically, such prejudice will be remedied with a continuance rather than a denial of the amendment. There was no motion to continue the trial in this case. The court went on to say the breach of contract claim was based on the same facts as the original Quantum Merowit claim, and they cite Dossman versus Hillsborough Regional Area Transit, which had a quote that said, leave to amend should be freely given, and more so when the amendment is based on the same conduct, transaction, and occurrence upon which the original claim was brought. That's essentially what we have here. The most persuasive case for the court to consider, in my opinion, is the Supreme Court's case of Jefferson Realty of Fort Lauderdale versus United States Rubber. It's at 222 Southern 2nd, 738. In that case, there was a breach of contract action between a landlord, who was Jefferson Realty, and the tenant, who was United States Rubber. They intended to build 3 stores on the landlord's property, and the case went before the court on damages. Just before resting their case, and on the 3rd day of trial, the original plaintiffs moved for permission to amend the complaint by adding Jefferson Stores Inc. as a party plaintiff because they had originally sued a subsidiary in error. And the defendant objected to the joinder, and the Supreme Court permitted the joinder, citing Rule 1.250, stating, we have examined the entire record and we are convinced—
Excuse me, Judge Sleet, have we lost Judge Kuzan?
It appears we've lost her in the screen. Let's see. Gentlemen, let's take a break.
She's back.
I don't know what happened. I disappeared and I guess I'm back. Sorry.
Did you
I was able
lose
to-
any? Did
No,
you
I
lose
was-
any
The
of the
important thing is that
arguments?
we stopped as soon as you disappeared.
Yeah, no,
did.
I was able to hear you all. I did not realize I was looking
Oh,
down.
good.
at
Okay.
My thing,
Go
then
ahead, sir.
Thank you. Thank you, Judge Casanueva.
Thank you. And so anyway, they said that Jefferson Inc. was not the only the real party in interest, but also the factors recognized by all the parties throughout the trial of the case. Therefore, the trial court was eminently correct in permitting the joinder of such party as a party plaintiff in the amendment. Our case is no different. The Ozer parents were always a part of the case. The general allegations in the complaint make it clear that the parents contracted for the installation of about $62,000 of cabinet work. And they were named as we've identified in the unjust enrichment claim. Importantly, just the appellants in this case just simply were not prejudiced, and they put on the exact same case that they would have absent adding the parents. We also cite the court to the opinion in Laget versus Blanco 521 Southern 2nd 299, where the court stated parties may be added by order of court on its own initiative or on a motion of any party at any stage of the action, and such terms are just citing Rule 1.250. And importantly, they indicate that the liberal rule permits the adding of parties by name even after judgment is entered, where required by the equities. And again, the equities are required here because the parents, were always part of the case, and that's what Judge Wolf found. I also cite Field versus City of Fort Lauderdale, which is a case that was decided after appeal and where an interested party was amended pursuant to Rule 1.25. Lastly, we think Kaufman versus A1 Bus Lines is persuasive. They granted a directed verdict at trial, and the third district overturned the directed verdict, finding error in the court's refusal to permit the appellant to amend the complaint. They concluded that A1 Tours was a proper party to complete the determination of the case, also citing Rule 1.250C. And this is similar to the Kaufman case because the parents were necessary for a complete determination of the case, and Judge Wolf was correct in allowing an amendment to the case. We asked this court to be mindful of the Supreme Court's mandate in Canankerous versus Canankerous, which indicates that the trial judge has the superior vantage point and rulings shouldn't be disturbed only when that decision fails to satisfy the test of reasonableness. As to point 2, the trial court is presumed to be correct, and the sign shop drawings, as I've indicated, showed that there were express contracts. So the trial court found express contracts, but in the event the court doesn't find that there were express contracts by the signature on the bottom of the plans, the competent substantial evidence test, shows that there was a ton of evidence. We had a 2-day bench trial with expert testimony. Mr. Carey examined Mr. Sanchez, the principal, for probably over 6 hours. And the appellants have frankly failed to demonstrate an absence of competent substantial evidence. These guys disagreed on everything. They wouldn't have agreed if the sun came up in the east and set in the west. So there's just a ton of conflicting evidence, and the trial judge credited Mr. Sanchez, the principal of Star Quality, over Mr. Ozer. Point 3, Star Quality proved the value of the benefits conferred. That was done through all of the detail that was contained in the change orders, which probably spanned at least 100 pages. And they found the unexecuted RFCOs were included in the breach of contract action. Therefore, the unjust enrichment claim became moot. But in the alternative, the damages for the unjust enrichment claim can be valued based on either the market value of the services or the value of the services to the party who was unjustly enriched. Star Quality established its damages through the testimony of both Mr. Sanchez and Mr. Hartman. My opposing counsel didn't say anything about Mr. Sanchez's testimony, where he detailed in the record the value of the RFCOs, many of which included materials, frankly, which just weren't even disputable. Lastly, damages to both houses were supported by competent substantial evidence. The appellant objects to this argument for the same reason as Judge Kuzam. It wasn't preserved on appeal. They filed a motion for rehearing, but then that went away when they filed their notice of appeal, and it was never heard by the judge. Regardless, it's not the function of the appellate court to reweigh the evidence so long as the findings and conclusions are supported by competent substantial evidence. There's no evidence that Mr. Ozer ever questioned the labor burden at the time he signed the 10 or so requests for changes, and Mr. Ozer approved 10 of the change orders with a 35% labor burden. and established a binding course of dealing. The trial court expressly rejected the argument that Star Quality overcharged the Ozers for labor. And in fact, it's absurd to think that skilled millwork personnel would be, $15 an hour, which is what Mr. Carey uses for his 400% and 500% overhead remarks. As to the labor burden, there was no general contractor on the job, and Max Sanchez had to supervise all of the subcontractors directly, which justified the markup. As to billing matters, the trial court determined that the appellants assented to and accepted the appellee's profit and overhead burdens. And the fact that the trial court questioned while Mr. Ozer failed to pay all of the contracts where he agreed and he signed on was found to be inequitable. So as a result, we asked the court to affirm the trial court on all areas. The lower court had discretion to amend the pleadings to add the Ozer parents under 1.250. There was substantial competence evidence to support the findings of the trial court on the unexecuted RFCOs. The appellee pled the unjust enrichment in the alternative, and the court found express contracts, but in the alternative, there was substantial competence evidence to support the ruling, and the damages were supported by competent substantial evidence, and they were not preserved for appeal. Thank you.
Judge, you're on mute.
Sorry, you have 2 minutes, sir.
Thank you. First, Rule 1.250C doesn't apply because this was not adding new parties. This was amended pleadings. Mr. Adams made the statement the parents were always part of the breach of contract count. I'd ask the court go back and look at count 2. There's no mention of the Ozer parents at all in count 2. So the 1.250C does not apply. The applicable rule is 1.190A. As the court knows, the court's discretion as a case approaches trial reduces to the time when the plaintiff rests its case. It is reduced to 0 because it sets nadir. In terms of the express contracts, the shop drawings that were signed preceded a number of the RFCOs, preceded a number of that work that was ordered during it. So there's no way that could constitute an express contract for all the unexecuted RFCOs, and there was never an agreement on price, which also precludes a contract on that. Mr. Adams made the statement that Max Sanchez testified as to the value of the cabinetry and the RFCOs. He made the same statement in his answer brief. He made no citation to the record in his answer brief because none exists. We went back and combed the record. There's no testimony on that, and therefore there's no testimony to support the value for unjust enrichment. And finally, last but not least, labor burden is payroll taxes, fringe benefit, workers' compensation, vacation pay, holiday pay. That doesn't exist with respect to subcontractors. Their own expert admitted that was error by the court to include that. So we respectfully request that the final judgment be reversed. Thank you.
Thank you, gentlemen. Well argued. Thank you and
Thank
have
you
a good
both.
day.
Thank you.
Our third case, Universal Property and Casualty